Nigeria's battle against the arbitrary award in the P&ID oil contract still has a long way to go. But where we stand now deserves a lot of commendation and back-patting, which is the reason a lot of people have made comments about the fight that resisted that arbitrary award. Of course, a lot of commendation should go to the federal government and the Federal Ministry of Justice, who championed the resistance. It's still a great battle ahead in convincing the court that the basis of that contract was fraudulent, and that can form a basis of overturning the arbitrary award. But as we speak now, there are still government agencies and organizations that have a duty to still continue to commit government in contracts and agreements. Now, what lessons are we learning from the situation in the P&ID contract? That is what we are going to be looking at. We are going to be talking to the man at the helm of affairs itself on this matter, the Minister of Justice, Abubakar Malami, Senior Advocate of Nigeria. Now, it is not the scale talking to him directly. He appeared on our flagship program, Good Morning Nigeria, to explain more on this issue. And because we found it very important, we are taking excerpts from that interview. Of course, we couldn't pin him down with it, the short time we had to put this together. But since he had spoken on this station, we decided to take part of it to educate us on why we can learn lessons from these kind of agreements and contracts which organizations and agencies have to sign for Nigeria. And so, let's take the first part of this program to listen to some of the submissions of Abubakar Malami, Minister of Justice and Attorney General of the Federation, on the P&ID contract.
Well, as the component of the issues, if I am to take you perhaps back, not assessing the background that has been stated, is let me start by way of being in agreement completely with the submissions made, with particular reference to the fact that P&ID contractual agreement was indeed a contract that was not intended to be, that was originally not intended to be executed ab initio. I'm entirely in agreement with that proposition. Why? First, this is an agreement that was signed between Federal Ministry of Petroleum Resources and P&ID for the supply of wet gas by Petroleum Affairs Ministry to P&ID for it to be processed to lean gas for power generation purposes, among others. But the question that calls for determination first is whether Federal Ministry of Petroleum indeed has the gas to supply. The answer is clear. The provision of gas is not within the mandate, it's not within the capacity and it is not within the within the capacity of Petroleum Affairs Ministry. It is indeed a function of oil and gas companies. Oil and gas companies, ADAX, for example, and ExxonMobil, that were expected to provide the lean gas through a pipeline that was intended to be put in place. But the point of interest arising therefrom is that ADAX and ExxonMobil were never parties to the agreement of an issue. So the issue is, can you provide what you do not have? Can the Petroleum Affairs Ministry provide a lean gas that it does not have? And taking into consideration that the ExxonMobil, the ADAX, were never parties to a contract. If indeed it was a contract designed to be executed ab initio, then it is only logical that it should be a tripartite contract involving three parties: the Petroleum Affairs Ministry, ADAX and Mobil on the other part, and indeed the P&ID. But the fact that you are now trying to shave someone's head while he is indeed not presently available for the shaving create an impression expressly that there are certain fraudulent undertones right from the onset. Now, this was the background against which the contract was signed between Petroleum Affairs Ministry and P&ID, without ExxonMobil and ADAX being part and parcel of the agreement, even when ExxonMobil and ADAX were expected to provide the desired lean gas from their facilities. Now, the agreement was eventually signed in 2010. And then, as of 2012, the issue of breaches, purported breach, was raised by P&ID. On which ground? On the ground that no pipeline was put in place by Federal Ministry of Petroleum to a point, expected point, of installation of the plant. But the issue is, where was the point? P&ID has not acquired a landed asset in rivers where the plant was expected to be put in place. P&ID has not acquired the necessary permits and approvals from Department of Petroleum Resources that will enable it to put in place the plant. P&ID has not shown any financial strength and capacity for the acquisition of the plant internationally, much less of having it put in place in rivers. So, but yet, notwithstanding these facts, the P&ID now commenced an arbitration proceedings on the allegation the Federal Ministry of Petroleum Resources refused first to provide the pipeline required to the purported point of installation. Two, Petroleum Affairs Ministry did not as well provide the gas, which ordinarily it couldn't have. So at the end of the day, they now instituted an arbitral proceeding. And then shortly after 2010, that was precisely in 2012, the arbitral proceedings commenced. And eventually, necessary processes, arbitral process in terms of documentation, were exchanged by the parties. Ministry of Petroleum Resources represented, P&ID represented. And among the point of further interest, in the course of arbitral proceeding, there existed a witness statement of a witness that died long before the proceedings commenced. Long before the idea of commencement of arbitration was raised, a witness statement was part of the statements that were presented for the consideration of the Court of Arbitration to look into and rely upon for the purpose of declaring a liability against Nigerian state. So, as at the time the government of President Muhammadu Buhari came in place, just a month or two thereabout, there was already determination of the arbitral proceedings, and Nigeria was adjudged liable and within the region of around $6.6 billion. But the point of interest is not only the liability, but Nigeria was adjudged equally liable in interest in the sum of over $1 million per day to continue running until after the settlement of the arbitral award. And that was the point at which the government of President Muhammadu Buhari came on board and took immediate steps. One, looking at the possibility, one component of it was the possibility of perhaps negotiating the arbitral award down, taking into consideration that there was nothing available on the ground to support the government in arriving at a decision one way or the other as to whether indeed there existed fraud, underhand dealings, corruption, and compromises in processes and procedure. Now, even before the government came on board, the previous government had indeed engaged P&ID in negotiations and were negotiating within the region of $801 or so million by way of out-of-court settlement. But then the time was running against them until the government of President Muhammadu Buhari was eventually sworn into office. So our immediate steps was to assess and analyze the whole situation from the perspectives of the possible settlement arrangement, from the perspectives of perhaps analyzing the whole scenario to see into it, to look into it, examine them, and see whether indeed there was justification for settlement in the first place. And our reaction there, thereafter was, even if the settlement component should be given any consideration, but arising from certain variables that were revealed, that manifested, we felt there were certain procedural compromises. And those compromises, we took steps now to analyze the contract. Some of the major revelations arising therefrom were the fact that, one, P&ID had not taken steps to acquire the land on which the facility was to be put in place. Two, P&ID had not taken steps to now obtain necessary permits, necessary approvals, or perhaps even the presentation of necessary feasibility before the Department of Petroleum Resources that could have allowed the company to put in place the facility. Three, the financial capacity of P&ID was as well suspect. Four, the agreement in its own right had not brought in ADAX and ExxonMobil that were expected to be the providers of the lean gas into consideration. So it was a bilateral and as against a tripartite agreement. An agreement of this nature should bring together all the parties of interest, the provider of the gas, the government agency involved, and indeed perhaps in the circumstances, the P&ID, if you indeed are not bringing the state that was expected to provide the land, on board. So apparently it was a bilateral agreement involving Ministry of Petroleum Resources only, and indeed P&ID now overlooking or sidestepping the ExxonMobil and indeed ADAX that were expected to be the providers of the lean gas. So more so, limited perhaps assessment of the whole situation does not exhibit or establish a financial capacity on the part of ExxonMobil. And their problem was further found on the part of P&ID. And their financial capacity was further established to have been suspicious, arising from additional revelations that indeed the $40 million they claim to have invested were indeed monies obtained from a Nigerian of interest, and he was along the line shortchanged by P&ID, a Nigerian provided the financial muscle required for the purpose of the project. They now took money from the Nigerian with an understanding that his company will be used for the purpose of acquisition of necessary permits, for the purpose of establishment of the facility. And yet, after collecting that money from a Nigerian, he was as well sidelined, and then they now use part of the money to perhaps invest minimal part of it while taking away substantial part of it out of Nigerian state without even paying the undertone necessary taxes associated with it. So perhaps our psyche was affected by the possibility of fraud arising therefrom. And then we now decided not only to engage in negotiations, but perhaps to see what we can do in terms of affording protection to the Nigerian assets locally and internationally, which they were targeting to attach for the purpose of execution of the arbitral award. What did we then do? We now decided to engage lawyers to now ensure at the end of the day that the enforcement they were aggressively pursuing internationally was stopped. And then we now engaged a company by name Curtis and instructed them to look at the possibility of ensuring that no enforcement was carried out against the Nigerian asset locally or internationally. But then, looking further into the limited revelations as it relates to the enforcement, we now come to understand that there were a lot of financial, perhaps, misdeeds involving the parties, both locally and internationally. And then a suspicion now arose that indeed P&ID originally was a product of fraudulent dealings among the parties, fraudulent compromises among the parties, and indeed breaches of processes and procedure, taking into consideration that all the required procedure relating to the acquisition of land, procedure relating to permits and approvals from the Department of Petroleum Affairs Ministry, procedure relating to the fact that not even the agreement was presented before the Office of the Attorney General for vetting, which is an office that is saddled with the responsibility of vetting agreements involving the government of the Federal Republic of Nigeria for the purpose of ensuring that the interest of government is adequately protected, looking into the existing and prevailing clauses in the agreement. A situation whereby as well, not even the Federal Executive Council was accorded an opportunity to look into, to deliberate and look into the agreement for the purpose of approving it. So a lot of processes compromises, a lot of procedural compromises, a lot of misgivings apparent that could now suggest or perhaps support the reasonable ground for suspicion of the commission of an offense, or perhaps maybe of compromises. So we now took a further decision that there is need now to attack the agreement in its own right, to attack the award in its own right. But our major predicament ordinarily was this is a process that you need to present before the court shortly after the award. And in most jurisdictions, it is within the region of 3 months. And we are here now, perhaps sleeping and going into slumber for over a period of 6 or 5 years, which is unprecedented for you now to now approach a court and say, look, I have been sleeping for a period of over 6 years. I am now here seeking for your discretion now to reopen the case for the purpose of certain consideration. But notwithstanding, we were hopeful on the ground that we were indeed cheated. The agreement was fraudulent, an agreement that now makes Nigeria liable in a financial sense, liabilities that will now bring down entirely the economic structure of the Nigerian state, entirely in respect of an award that has the capacity to deprive Nigeria of any further investment in budgetary sense, in educational and perhaps sense. It is an award that is far more greater than the entire budgetary provision of Nigerian state as it relates to health and education combined. So we felt, no, it couldn't fly. We have to make extensive efforts. And that is how a collaborative approach to it was sanctioned by the presidency, and we were directed to now look at the possibility. So that is where the collaborative approach to it now arose. a collaboration between the Ministry of Justice, a collaboration with the Ministry of Information, the Office of the Inspector General of Police, the Central Bank of Nigeria, the Ministry of Finance, EFCC, among and other institutions of interest that are in one way or the other, inclusive of the Foreign Affairs Ministry that was saddled with the responsibility of providing the associated support services, inclusive of the Secretariat, taking into consideration that we have to find our way to foreign countries for the purpose of establishing our case. So eventually, at the end of the day, we now instituted a further action seeking for extension of time. One, stay of execution of the order of the payment. We decided to now provide a kind of safety for the national assets. And then the starting point was to ensure that no enforcement is carried out. And then we have an order for enforcement. We applied for an order for stay of execution. The order was reluctantly granted by the court then on the condition that we were to pay $200 million cash deposit before the court. Then we equally felt that the order for conditional payment was unjustified, and then we appealed against it, seeking for the variation of the order, that we were not willing and ready to deposit that amount, because in case we do, and P&ID now eventually gets the $200 million, I think that could be the end of it, taking into consideration the unfolding revelations. So we've appealed against the order, for conditional order for deposit, and then we now turn around to initiate the process of seeking for extension of time within which to have the agreement and indeed the entire arbitral award set aside. But then, that application is unprecedented, taking into consideration the time limitation. You are expected perhaps at most to present such reconsideration within 3 months. And then here we are, after 6 years, now coming back to the court, seeking the discretion of the court to allow us. Outside the limit. Outside, long after the limit. Yes. So at the end of the day, we were lucky. The court now looks into the prevailing evidence. First, we equally applied before the court while our application was being considered to allow us leave to embark on international investigation of the parties of interest. And that investigation reveals that there were certain financial underhands relating to P&ID and some officials of government. And the sum of around 301 million naira then.
Is it million naira?
It's million naira.
Okay.
It's million naira, in case I have I was mistaken. But I mean, in stating a contrary currency before now. But the precise amount that was established to have changed hands then, that was between 20. Imagine the 301 million naira in 2010 was established through our investigative exposition in other jurisdictions. And now we equally, with that investigation at hand, we equally support our case. And the court now agree with us that we were not only entitled to extension of time within which to apply for the setting aside of the entire award, for the nullification of the agreement, but then the court was convinced that there was strong revelations in the direction of fraud, compromises, and indeed corrupt practices among officials of government and P&ID. And indeed, there is strong suspicion that P&ID contract was a product of fraud, compromises, corruption, and certain underhand dealings between the officials of government and P&ID.
Let's hope that it would end well in favor of Nigeria, because it is at the stage where we are told to come and restate our case why that arbitral award should not be made or should stand against Nigeria. Thank you for being part of today's program. I remain yours, Femi Okeowo, with the pleasure of having you around with us, and you know that issues continue to evolve in the justice sector of Nigeria. You can always trust that the scale will always be on top of them. We'll see you again.